And it is Chris Valentino from Jackson Lewis. We are on the precipice of an extended weekend, so very exciting. Memorial Day, we didn't think we would get here. I presume that there's probably one person on the phone with me, but I appreciate you dialing in because today's one of those days where everybody takes off. But if you did dial in for this, we are going to talk about a very important topic, and one that I constantly get phone calls this time of year on, and it is dealing with interns. We need to, from an HR perspective, we need to understand what the Second Circuit / New York guidance is as it relates to interns. So many times, right before summer begins, and high school seniors in high school are looking to put something on their resume, and people coming home from college, and even in my world, graduate school, when you have law students, they will send you letters, and you will get a call from, an acquaintance or somebody that we network with that says, well, my son or daughter is looking to do X, Y, and Z. Can they come in and that you don't even have to pay them. They want the experience, and they want to put something on their resume. And we're tempted to do it. And if our approach to this is, well, it's free labor, then our approach is wrong, and we're going to get whacked. All right. Nothing is in this world is free unless you're providing something in return, which would make it, not free. And that is really the approach that our courts and our Department of Labor has taken to assessing interns in New York. Let's get started. As I laid out, it's the months of May and June that I get the most calls on the SHRM hotline and from clients about internships with people, returning from school. And the question always is, I'd like to do this for them. Do I have to pay them? And my answer is commonly, yes, you do need to pay them, and we go through an analysis as to why that is. Prior to 2015, there was a significant amount of confusion with regard to whether or not an intern is really an employee, or you could couch this person as an unpaid intern. This was an issue that went back and forth in our courts. You had competing visions as to what an unpaid intern is. And ultimately, in 2015, we got a decision from the Second Circuit, which is in New York, our highest federal circuit court, our highest federal court on what is an unpaid intern. They gave us a lot of good guidance, and I wanted to review that with you today as you assess your different workplaces and your circumstances. Now, I will lay this out because in my work with SHRM Long Island and a lot of its members, I know that there are a lot of nonprofits that are involved in SHRM Long Island and participate. The GLAT decision is dealing with for-profit companies and unpaid interns in a for-profit company. They make a point, and the Department of Labor has made a point in saying, in a nonprofit world, the rules may be different. I think that they're relaxed, but if you are a nonprofit on this phone call or listening to this recording, I think that you play a very risky game when we don't follow, at least to some extent, the guidance that we received in GLAT. I want at least all the clients that I work with and the people that I work with in SHRM Long Island, I want them following the guidance laid out in GLAT, regardless of whether you're profit or nonprofit. It just gives me a sense of comfort. Okay, so in 2015, we had the Second Circuit give us this decision, which established a new test on whether unpaid interns working with an employer would be considered an employee under the FLSA. If you are an employee under the FLSA, you must receive compensation for all hours worked. If you are not considered an employee and you are an unpaid intern, then ultimately you need not be compensated. Right. and I say FLSA in addition to the New York State labor law, which requires employees to be paid either as on an hourly or salaried basis, exempt or non-exempt. Right. So here is what GLAT, and it's an interesting decision, and it's one with a significant amount of case history, but here's what GLAT boiled this issue down to. They look at who is the primary beneficiary of the relationship, examining on a case-by-case basis the circumstances under which the intern is working with the employer. Who is the primary beneficiary of the relationship? Is it the employer, i.e., the intern providing services to the employer that other employees may ultimately be doing in exchange for compensation? Or is it the intern who is the primary beneficiary, receiving some level of experience and education that is of value to them, to a large extent to the hindrance of the employer? That's our analysis, all right? The test focuses on what the intern is receiving in exchange for the services and accords courts, the evaluators of fact, the flexibility to look at these on a case-by-case basis, examine the economic realities of the relationship, and reach a conclusion as to whether or not the intern is in fact an employee. Subsequently, after the decision in 2016 on revisit, the court added that an intern must truly expect a unique internship relationship. All of that is laid out in a couple of factors, which we'll get to in a second. But I always counsel employers that call me up on this. I said, look, if you want to be safe on this, make sure that you are aligning yourself with the intern's educational needs or their study that they're currently undergoing. For example, you have somebody who wants to come into your HR department and be an intern for the summer. Okay. Tell me, what is this person studying in undergrad or grad? Are they studying human resources? What does their syllabus look like? What courses are they taking? Have we called the school to find out whether or not the person can receive credit for interning in your business? Have we touched base with the individual's professors or their dean to determine what are the goals of the summer internship program? The more you can align yourself with the educational desires and needs of the intern, the better off our argument is going to be. And at the bottom of this slide, I put that as a nota bene. All right. So what did GLAT do? The GLAT said in basically, very broad terms, we are going to examine who is the primary beneficiary of the relationship. We are going to look at the economic realities of the relationship. But then the court went a little bit further and said, let's give the employer a checklist. And let's make the employer go through this checklist to determine or help them determine whether or not this really should be paid or unpaid. Okay, and here are the checklist criteria or the considerations that employers should be looking at before reaching a conclusion. First, does a clear understanding exist between the intern and the employer that there is no expectation of compensation? Are you clear at the outset of the relationship that it will be unpaid? And how do we do this in the very best fashion? We do this in a written form, laying out the expectations so that nobody has confusion and this issue is not ambiguous. Two, all right, does the internship provide training similar to that given in an educational environment? I come back to my rule of thumb. Are you connecting in some way, shape, or form the information that this individual is being provided during their internship period to their course of study, their educational environment? Are you taking time each week, maybe each day, to sit down with this person, explain what you're doing and why you're doing it? Does it mimic, does it mirror a classroom or an educational setting? Very important, all right? Is the internship tied to the intern's formal education program? I come back to something I said earlier. Before you bring on an unpaid intern, are you contacting the school? Are you speaking to the chair of the department that this person, or the school that this person goes to try and connect this in some way, shape, or form to the educational program that the person is receiving? Can they get credit for it? I love that question. And I think in my conversations with the Department of Labor, it's something that is really very, very telling on whether or not somebody is appropriately classified as an unpaid intern. If they're receiving some school credit, even if it's a half a credit for working with you during the summer or during their internship period. Okay, 4 more that I want you to consider. Does the internship accommodate the intern's academic commitments? If you have somebody who comes in and is working with you in an unpaid internship, are you making exceptions for this individual to attend classes, to attend seminars that will further their degree and their career? If they have meetings, with their dean or with their professors or teachers, are we giving them the ability to leave their assignment with you and go? Are you supporting their educational career as opposed to being a hindrance to it? All right. Is the internship is it for a limited period of time? I love when, I'm looking at a situation where you have an unpaid intern who's working there for an extended period of time, 6, 8 months, a year. That to me makes no sense. I don't know how you can align that to an educational situation if you have an open-ended internship, all right? So make sure in that initial writing to the intern that you are considering that it will be unpaid. Here are the expectations for the position. Here are the different, educational steps that we'll take to meet with you and talk about what we do and how we do it, blah, blah, blah. And ultimately, this will be for a 3-month period of time. This will be for a 10-week period of time, whatever it may be. All right. One of them, although none of these factors are dispositive, one of them I think always is a little bit more heavily weighted than others, and it's this 6th bullet. Does the intern's work complement rather than displace the work of a paid employee? Whenever I get involved in disputes with the New York Department of Labor over somebody's classification as an unpaid intern, the first thing I look at and the first thing they look at is, do you, the employer, have employees that are getting paid to do the exact same work as the unpaid intern? If the answer to that question is yes, all right, I think we have a potential problem. Now, if the intern is doing similar work, but not entirely the same. For example, they are being tutored on how to do certain projects, and then they are being educated in a classroom setting about why we're doing them certain ways, and we're getting a college or a high school credit for it. I think you can distinguish that situation from somebody who is doing an unpaid internship. They're going to be working in your mailroom, and they're going to be working alongside other people who are getting paid to do the exact same thing, stuffing envelopes, doing data entry, answering phones, writing messages. And that to me is not an unpaid intern. That's an employee. And finally, is there a clear understanding that there will be, or there is no guarantee that the intern will receive paid employment at the conclusion of the internship? Right? Again, we can lay that out in an offer letter, very important. These are the things that the Galat decision advised us that we should be thinking about. I have highlighted and bold and italicized, these 7 just to shorthand these criteria. We should be thinking about them and making sure that we are following these and can answer them in the affirmative. The more that we can answer in the affirmative, the better off we are going to be. Right? Your offer letters and your internal policies should focus on these considerations and make sure that we are aligning our unpaid intern programs with these criteria. Right? And again, take a step back. As the CEO, as the CFO, or whomever in your business decides we're going to bring this person on, but we're not going to pay them, think about GLAT. Who's the primary beneficiary of this relationship? It is not enough. It's not enough of a benefit to an unpaid intern for them just to put something down on their resume that they worked with you. It's just not enough. That's been tried and it's failed. We need more. So let's make good decisions here. Okay, that's unpaid interns. Anybody has questions, feel free to email me or feel free to give me a call. Happy to discuss. One other issue that I wanted to touch base with you on today in my final 4 minutes is the New York City Freelance Isn't Free Act. We are Long Island employers. Some of us have operations in New York City, most of us don't. I'm not going to take a lot of time to talk about New York City laws on this call, except when I believe that a New York City law could trickle up to Albany and become, an agenda item for the state. And I think this is probably one area. All right. New York City has adopted this Freelance Isn't Free Act to cut down on abuses within the gig economy. The employees are one thing, but when you have freelancers, independent contractors, and employers are creating relationships with independent contractors, sort of all over the place, there needs to be some regulation, and this is New York City's response. It was effective May 15th, 2017, right? It'll be overseen by the Office of Labor Standards. What is the law? It requires parties to a freelance arrangement, employer, a company, and independent contractor. If that contract or if the services are valued at more than $800, we are required to have the terms of that arrangement outlined in a written document, in a written contract. You must have a independent contractor agreement with these individuals. It requires businesses to pay appropriately and timely in accordance with the terms of those contracts. It prohibits retaliation, and ultimately it has its own creation of damages, which includes, most importantly, double damages in the event of a violation. Does not preclude a freelancer from bringing an independent breach of contract claim. Okay. As I said before, it must be in writing if the contract is valued at more than $800. The failure to create this written contract will ultimately entitle to the freelancer to some punitive damages, which includes $250,000 if the freelance requested a contract and was denied. In addition, there's double damages, increased damages equal to the value of the contract if the hiring party violates other provisions of the law. Basically, our takeaway on the FIFA is have it in writing. You should have it in writing. Any relationship that you have, we should lay out the terms. A couple of years ago, New York State adopted a law requiring employers to have commission agreements in writing with employees. And if you don't, you are presumed to have violated the arrangement. These are not good things to just leave verbal. All right. Make sure that we have a document. These contracts are so easy to draft. It makes no sense not to have them. All right. Paid timely and in full. Hiring parties must pay on time and in full within 30 days of the completion of the work. Don't extend out, your payment terms beyond that 30-day period. Again, all things that we can address easily and quickly in a written document with a freelancer. You're not talking about a 10-page document here. It could be something as simple as a 1-page document which lays out essential terms. And remember, like all of the other laws that are being passed in New York City and New York State, there are anti-retaliation provisions included herein. So we have covered the unpaid internship. We've done a tutorial on that. You now know your 7 criteria that you should be looking at if you are a nonprofit. Even though the law doesn't or GLAT doesn't specifically apply to you, I want you to use those law doesn't apply to sales representatives, attorneys, or licensed medical professionals. If you're dealing with any of those, certainly give me a call and we could talk about how to structure those relationships. I wish you the very best and happiest and enjoyable Memorial Day. I hope that the rain stays away for us on Long Island, but even if it doesn't, maybe taking a quick break for 3 days will do the body good as we go into the summer. Hope all is well. Thank you for joining, and we will speak next month. Thanks. Bye-bye.